is the only circumstance recognized by Florida law that could result in a defendant receiving a death penalty. An aggravating factor increases the gravity of the crime or the harm to a victim beyond the harm inherent in every first-degree murder. You must not consider any other facts as an aggravating factor other than what has been alleged and proven by the state beyond a reasonable doubt. The aggravating factors alleged by the state in Count 1, first-degree murder of Christine Melton, are: 1. Wade Wilson was previously convicted of a felony and was under sentence of imprisonment or on community control or on felony probation at the time he committed the first-degree murder in this case. 2. Wade Wilson was previously or contemporaneously convicted of another capital felony or a felony involving the use or threat of violence to another person. A. The crime of first-degree murder is a capital felony. B. The crime of first-degree murder is a felony involving the use or threat of violence to another person. 3. The first-degree murder was especially heinous, atrocious, or cruel. Heinous means extremely wicked or shockingly evil. Atrocious means outrageously wicked and vile. Cruel means designed to inflict a high degree of pain with utter indifference to or even enjoyment of the suffering of others. The kind of crime intended to be included as especially heinous, atrocious, or cruel is one accompanied by additional acts that show that the crime was conscienceless or pitiless and was unnecessarily torturous to Christine Melton. 4. The first-degree murder was committed in a cold, calculated, and premeditated manner without any pretense of moral or legal justification. Cold means the murder was the product of calm and cool reflection. Calculated means having a careful plan or prearranged design to commit murder. A killing is premeditated if it occurs after the defendant consciously decides to kill. The decision must be present in the mind at the time of the killing. The law does not fix the exact period of time that must pass between the formation of the premeditated intent to kill and the killing. The period of time must be long enough to allow reflection by the defendant. The premeditated intent to kill must be formed before the killing. However, for this aggravating factor to apply, a heightened level of premeditation demonstrated by a substantial period of reflection is required. A pretense of moral or legal justification is any claim or justification or excuse that, though insufficient to reduce the degree of murder, nevertheless rebuts the otherwise cold, calculated, or premeditated nature of the murder. You've heard evidence about the impact of this murder on the family, friends, or community of Christine Melton. This evidence was presented to show the victim's uniqueness as an individual and the resultant loss by Christine Melton's death. However, you may not consider this evidence as an aggravating factor. The state has the burden to prove an aggravating factor beyond a reasonable doubt. A reasonable doubt is not a mere possible doubt, a speculative, imaginary, or forced doubt. Such a doubt must not influence you to return an aggravating factor if you have an abiding conviction that it exists. On the other hand, if, after carefully considering, comparing, and weighing all the evidence, you do not have an abiding conviction that the aggravating factor exists, or if having a conviction it is one which is not stable but one which wavers and vacillates, then the aggravating factor has not been proved beyond a reasonable doubt. A reasonable doubt as to the existence of an aggravating factor may arise from the evidence, a conflict in the evidence, or the lack of evidence. If you have a reasonable doubt as to the existence of an aggravating factor, you must find that it does not exist. However, if you have no reasonable doubt, you should find the aggravating factor does exist. A finding that an aggravating factor exists must be unanimous. That is, all of you must agree that each alleged aggravating factor exists. You will be provided a form to make this finding as to each alleged aggravating factor, and you should indicate whether you find each aggravating factor has been proven beyond a reasonable doubt. If you do not unanimously find that at least one aggravating factor was proved by the state beyond a reasonable doubt, then the defendant is not eligible for the death penalty and your deliberations are complete. If, however, you unanimously find that at least one aggravating factor has been proved